Hello, citizens. Okay, imagine this. You survive a horrific crime, and the medical evidence proves you're telling the truth. You point right at the attacker in court. But then the judge lets him walk free because you got the time of day slightly wrong. Sounds unfair, right?
It sounds impossible, but it actually happened. A high court acquitted a convicted attacker over a mathematical technicality.
Wait, what? Just because of a timeline issue?
Exactly. But the Supreme Court stepped in with a landmark ruling in state of Himachal Pradesh versus Hukumchand. And it changes everything about how we look at witnesses in India.
Okay, I need to know what happened. Who was the witness?
A 9-year-old girl in Himachal Pradesh. Her mother sent her to get buttermilk from a neighbor. But on the way back, Hukumchand dragged her into a cowshed and sexually assaulted her.
That's horrific. Did her parents go to the police immediately?
They did. They filed an FIR and doctors found concrete, undeniable medical evidence of the assault. The trial court convicted him under Section 376 of the IPC, the law for rape, and gave him 10 years.
So the system worked. Why did the High Court let him go?
Because of quote-unquote improbabilities. The High Court calculated that she would have had to walk 16 kilometers in 2 hours to fetch the buttermilk.
So they turned a crime scene into a math problem.
Exactly. Plus, the two families had a history of petty quarrels over grass and firewood. The judges assumed she was tutored to lie for revenge.
Hold on, so you're telling me they threw out hard medical evidence because a 9-year-old's walking speed didn't add up on paper?
Precisely. And that brings us to the big legal showdown. The state appealed to the Supreme Court. Now, normally, under Article 316 of the Constitution, the Supreme Court doesn't interfere with acquittals.
Right, Article 316 is their special power to grant an appeal. Why wouldn't they use it?
Because they usually trust the lower court's assessment. But here, they ruled that if a high court misreads evidence so badly that it causes a gross miscarriage of justice, they absolutely will step in.
But what about the fact that she was only 9? Can a child's solo testimony actually put a man in jail?
Yes, relying on guidelines from the Chatra case, the court said age doesn't matter. Competency does.
Meaning, does the child know the difference between truth and lies?
Exactly. This brave girl survived brutal cross-examination by defense lawyers without changing her story once. Her testimony was rock solid.
Wow, she didn't break. But what about the 16-kilometer math problem the High Court obsessed over? And this is where the Supreme Court dropped the hammer. They explicitly stated that human memory isn't a stopwatch. You cannot demand mathematical precision from a traumatized victim, especially when medical evidence proves the crime happened.
Exactly. Honest mistakes happen. But I heard there was something else in this judgment. Something about the courts messing up her privacy?
It was shocking. The lower courts had freely used the minor's real name in their public records. The Supreme Court justices were furious.
Wait, isn't that illegal? I thought the identity of a sexual assault survivor is strictly protected.
It is. Section 228A of the IPC explicitly guarantees victim anonymity. The court cited the famous Nipun Saxena case and blasted the lower courts for their indifference. They issued a strict nationwide directive to lock down victim privacy.
So the Supreme Court reinstated the 10-year conviction and protected her name. That is a massive win.
It is. For lawyers and law students listening, the takeaway is clear. Stop relying on hyper-technicalities. Manufactured timeline issues during cross-examination won't outweigh solid medical proof.
And for regular people, if you're ever a witness, don't panic if your memory isn't 100% flawless. An honest mistake won't destroy the truth.
Exactly. The law values the substance of justice over human error, and it will fiercely protect your identity while doing it.
Substance over technicalities. Now that's a precedent worth remembering.